address the most various issues relating to mediation, both in Russia and internationally, because indeed this is one of those institutions which is of key importance for on the global basis, on global level, and both the even civilization level, I think I can say so. I would like to introduce our speakers, and considering the fact that the program of this legal forum is very packed, which is good. So some of our speakers may have to leave in the course of the proceedings, our roundtable discussion. Some of them will not be able to sit until the very end, though I know that everyone would be desirous to listen to the end of our discussion. Nevertheless, I would like to say that we will have used the chance that the lunch starts at continues until 3 hours, and that's why our roundtable will continue until 2 hours, 14 hours. Let everyone knows there are a number of issues which we would like to discuss, and I think that all of you should be interested to listen to those presentations, because our moreover our speakers are experts in their in this field. Our roundtable discussion has the pleasure of company of Veniamin Yakovlev, whom we're very thankful to for his unswerving support and for his participation in the process of supporting on the mediation in this country. And his opinion, his professional opinion, his expertise is very important for us. We also have the pleasure of company Vladimir Pligin, who is the one of the eldest parliamentarians, a person who was from the very outset of the beginning of the mediation in this country, was part and parcel of this, has been a part and parcel of this process, one of our key allies who supports us in all our endeavors. We also have the benefit of the pleasure of our foreign colleagues who are chairman of the Hague Conference, Hans van Loon. He is a person who has spent a lot of his time, or his professional career, to develop international law. And of late, I see how much attention he is paying to development of mediation to be adopted as a universal means of resolution of disputes, should be included in all areas of international law and dispute resolution. We also have the benefit of former Deputy Speaker of the European Parliament, Diana Wallis. Diana has made great efforts to adopt a directive on mediation, which has been active since May 2008, and alongside with her enormous responsibilities, which she carried for more than 12 years, being Deputy Speaker of the European Parliament. She paid a lot of attention to development of various fields of application and mediations in a variety of spheres of human endeavor. We also had the pleasure of Fernanda Paulina Pereira. He is a person who is responsible for the e-justice in the European Union, for the European Parliament, and it is he who should be thanked for the establishment of the e-justice system, which is one of the global example of formation of electronic justice and use of instruments of electronic justice within the framework of the European Union. Our roundtable will also benefit from the participation of Konstantin Dobrinin. He is a senator in our Russian legislature, Federal Council. Recently, he when he took his office, and one of the first events which he participated in was an event dedicated to mediation, which is very close to our heart. And we know that the generations of new lawyers is prepared to support mediation. We thank you for being with us today. We also have the pleasure of Lyudmila Novoselova. She is chairman of the Intellectual Property Rights Court. This is an absolutely new institution which was formed under the aegis of the Supreme Arbitration Court, and which is a court dealing specifically with intellectual property rights. And I think this is a great leap forward in development of justice in our country. And from the very outset of establishment of this court, she displayed interest in having in mediation integrated as a part and parcel of the activity of the Intellectual Property Rights Court. It's also my great pleasure to introduce to you Alexander Nesterenko. She heads a non-profit partnership of Russian Corporate Council Association. This is a great and the great role she played in seeing these lawyers. Clubbing them together, bringing together lawyers who represent various companies in this association. So I believe that the involvement of corporate lawyers in the activity of development of mediation, and I believe that our local colleagues, foreign colleagues will agree, it's a great importance. We see even the presentation of our minutes is of great importance, and I will give you the floor. I would like to say that it's not only in Russia, but in globally as well. We see a lot of events testifying to the fact that mediation becomes more and more, needed in our activity. Quite often, they ask us questions that the law on mediation has been in effect in Russia for more than 2 years. However, there is very limited practice accumulated so far. Recently, we conducted a meeting in the Ministry of Labor, and they asked us, what statistics do you have in terms of the application of the mediation? Yes, of course, it's too early to speak about statistically proven data relating to the application of mediation, but I think this practice is growing up, is coming up, and it's very important. And mediation is actually penetrating in various spheres of our life, and it's very important for us for it to see that it is now wanted and demanded not only in commercial disputes, not only in family disputes, not only in labor disputes, but also in a system of child protection. It is taken inroads, if you will, in the social sphere. Last year, for example, President Putin signed a national strategy for child protection within the framework of implementation of this strategy. A network of mediation center is provided for. So we can say safely that indeed mediation is becoming a part and parcel of our life. It is seizing, if you will, the minds and hearts of the Russian citizens. And one of the most great supporters for us are lawyers. They are this is the largest professional group which we can lean against. Their allies, and the community of judges is also very important. That's why I would like to say that I'm very honored to have judges among our midst. Lyudmila Alexandrovna and some of the other speakers who was involved in setting up the system of arbitration laws, mediation laws. I would like to give the floor now to Veniamin Yakovlev for him to make his, keynote address, if you will. Thank you. I studied the audience and I saw I like your faces because I believe that such a noble procedure as mediation should be entrusted only to good people. Why so? Because sometimes you hear people saying about mediation, they say about the person of a mediator. This is not true. I think we sort of shifting stress. I think that parties, negotiating parties, are the key players. So, and they have found the strength and the wisdom to come together without taking each other to a court, but based on the law, based on the harmonization of their interests, to untie the knot which has been created in their relations and to carry on some joint activities or whatever. And live together, if you will. I would go as far as saying that the court, regular court, though I am a judge myself, is a war. A negotiation, mediation, including expert mediators, is a peaceful procedure. So that's why we have a choice between war and peace. What is better? And I believe that humankind, over the, say, long history of its developments, should come to the conclusion that peace is better than war, is the best means of resolving any conflict, whether it is a conflict between husband and man and wife or between states. So we have been witness to situations, of sad situations, when this truth is not accepted, is not shared, understood by many. Look at this Abramovich-Berezovsky, case. Everyone heard about that. The court procedure. Good court, no doubt about that. What was the result of the court? Full victory of one, full defeat of another. And finally, Berezovsky left this world. It's a tragedy, as a matter. The other party, who was the winner, would not, should not feel happy, I would say, if we look at it from a human point of view, as far as the Berezovsky is concerned. So we see the loss of capital, we see colossal court expenses, about 80 million pounds of sterling was spent for the court procedure, many other things. So whether he was killed, whether he committed a suicide, it doesn't really matter. He's gone. And this conflict actually has resulted in the death of one of the parties. This is a very vivid example of how what the war can bring in court can bring us to. And we should draw lessons in that. That's why it was not by chance that one of our greatest Russian writers, Nikolai Gogol, wrote a novel about the quarrel of two neighbors, a very analogous situation when the dispute originated from a trifle. And the court where Abramovich and Berezovsky took their case to, in the very court procedure, due to the reforms of which is taking place in the British court, the reform was named after the British Judge Wolfe, as a matter of fact. The core of the reform is that the competition in the court has been augmented by a chance to provide full legal information by both parties, proceeding on the fact that each of the parties within the framework of the court proceedings has the right to get the entire information which it may need to resolve this issue, right? This is a good. So the parties are mandatory, obligated to show reveal all of the information, disclose all of the information. And due to such preparation of the deal, 80% of the cases in such law do not come to the final hearing. Either the plaintiff recalls his claimant, or the judge terminates the proceeding, or the respondent voluntarily meets or the say judge approves a mediatory agreement which they finally make with themselves. So you will see that in the English legal procedures, court procedures, we see a part of mediation. I think this is a very good augmentation of the British court practice, and I would definitely support that our Russian laws, especially dealing with commercial disputes, should base their work on these principles, so that to the best extent possible. As few cases would come to the final hearing, but would be, say, sort of resolved at preparatory phases, because mediation is the most civilized way of resolving the conflict, because a court decision does not remove the grounds for the, say, content, for the dispute. It simply stops the case. So that's why mediation is an answer to the question, because it regulate the, say, disputes rather than stops the litigation. And our society, for this very purpose, needs as many, say, retaliatory procedure, because this is a remedy for making our relations, our human relations within our society as healthy as possible. And it's one of the most important tasks which we face. And we, lawyers, should do everything we can do so that it should take place, so that in our approaches we don't have a situation when we Russians are very fond of telling jokes. Well, one of the such jokes was the two neighbors, for example, one leaving for business trip, left with the other, his cow, say, in custody of the other neighbor, so that the milk should stay with the second neighbor and the cow would be returned. But then a calf was born in the process of the business trip. So the owner, the second owner, does not say that the calf is mine, but the owner of the cow said the cow is mine, the calf is also mine. They came to the same lawyer, and the owner is asking, well, do I have a chance? Yes, we can try. It has a lawyer. And then the temporary owner comes and says, asking, do I have a chance? And the lawyer says, yes, you can try. And his wife, the lawyer, says, you can say yes to both of the contending parties. He said, yes, but this will be for the court to decide. But the cow will come to be our possession. That was the answer of the lawyer. So this is yet another argument in favor of literary procedure, because literary procedure will say place everyone to his place, and the legal fees will be much less. And even the best lawyers in our time could requalify themselves and become mediators, because they would earn money, but not by instigating the patients, but rather by pacifying the contending parties, showing them the way how they can regulate the conflict on the basis of mutual interest, and agree and accepting the interest of the other party. Let us move along this road. There is nothing new for the Russian society in the mediatory procedure, because the mediatory procedure is our long time, deep-rooted Russian legal tradition. Before the Bolshevik Revolution, 1917, there was a system of commercial courts, and commercial courts was the beginning of the legal reforms. They were set into effect in, 1890, and the commercial courts very widely used mediatory procedure, reconciliatory procedure. So before the court, during the court process, and then after the court decision is made at the point of elimination, and Mikhail Spiransky, a famous Russian lawyer, was the founding father of the system. So he saw his responsibility in helping the contending parties to find the common procedure, to leave their dispute, to make end their dispute in peace. That was the peculiar feature of the Russian commercial court before the Bolshevik Revolution. And the common judges were also supposed to bring the contending parties to a peaceful solution, and the very name of the conclusion was the peaceful solution. And in the Soviet time, for example, we had a system of the obligatory negotiating procedure before, filing the documents in the court. Though it was not without the participation of the mediator, but nevertheless, this procedure, mandatory procedure of discussing issues was there in the in Soviet courts. What should we do to move this process at a faster pace? Three conditions are required. The first condition is a willing will of the contending parties to enter into negotiations. I think that the business community are clever guys, and they build their relationship on the contractual basis. So this is something which is very inherently known and acceptable to them to enter into a reconciliatory, say, procedure in order to stop the dispute. It's very great that our entrepreneurs, various foundations, Federation of Entrepreneurs, also part and parcel of the process of introducing mediations. The second condition is the presence of professional mediators. I know that in many big cities, many regions, in Moscow and St. Petersburg, here in my native Yekaterinburg, in Voronezh and Rostov, many Russian cities, they train mediators, and they train it in a good way. So we do have mediators, and Susanov Tandilna, who is the say, chairman, president of the non-commercial partnership for mediation center. I saw a very good publication about mediation, very good magazine. A lot has been done. And the third requirement is support by the government. The government has been displaying their great interest in that. A law on mediation was adopted in this country. Now the highest arbitration court is trying to introduce what we call court mediation, which should be used in the course of the court procedures, which is good. And they suggest to do that in a mandatory way for, say, tax disputes, because mediation can be voluntarily or it can be mandatory, say, mediation. And the directive which was referred to, European directive, allows for mandatory mediation if both parties if it is provided by law or if the court has sufficient power to do that. No matter. It does not really matter, because quite often, say, parties continue to carry on with their presentation, with the negotiation in a voluntary manner, even if they were prompted to start mediation. So I think that lawyers, the lawyers community, should, I think, be engaged in this process in a big and serious way. I mean, introduction of the modern civilized methods of, say, regulating conflicts, where we will show more respect for ourselves and others will respect us more. Thank you very much. Thank you. Okay.
Thank you so much for your statement, for highlighting the main points of interest in the development of this issue. Our country, just like any other jurisdiction, still lacks mediation, and the parties in a litigation hesitate for various reasons to apply mediation, even in small-scale conflicts. Parties in a conflict usually are antagonistic, and that's exactly when and where you need a mediator to bring down the scale of arrogance and aggression between the parties. Now, I would like to give the floor to Vladimir Nikolaevich Pligin. Unfortunately, he has to leave early, but it is important to hear his opinion. Thank you so much. First and foremost, I would like to ask you as a mediator to adjust the joke that he cracked a bit earlier. It was not the entire cow that was appropriated in favor of the court, only one third of it. All right, all right. Now you've mentioned one important aspect. Mediation is a paradigm shift, is a passage from confrontation to dialogue. It is a very important and difficult transition. It took humanity several times to make this transition, and we have historical experience. I believe that your personal career and your personal effort bespeaks of the importance of this procedure. In my opinion, we need a certain critical mass of references, of public exposure of mediation to expect a quantum leap in the public conscience. Let me say again. Now, on the one side, it is a very good fact that more conflicts and disputes are litigated outside court. On the other hand, there are negative aspects to that process. Moreover, a certain number of disputes cannot be settled outside court, like tax litigation or customs or whatever. The government is very interested in having a functional judiciary that would maintain competencies and create a body of practical law enforcement. I would partly accept your position. In order to pass legislation regulating mediation, we need to move quickly. We already tried to introduce a draft which was incorporated in a later draft. Our text suggested that the litigating parties had to first apply the institution of mediation. This is very important as a principle. Yesterday, the State Duma had the first reading of your proposals on the process of self-regulating organizations in mediation. Hopefully, during the current session, and given your active cooperation as well as active involvement of other stakeholders, we will be able to move on to the second and third readings, completing the entire parliamentary procedure and enacting this law already this year. So please pay attention to this. Well, in other words, there is every measure of interest from virtually every stakeholder to move things along. The society and institutions are prepared to address this issue once and for all and to pass a long-awaited piece of legislation. I can easily guess that you are often asked a question about the numbers. However, what I suggest, let's keep figures apart from the substance. Statistics is not very revealing in terms of describing the general situation. There's yet another aspect. Just recently, on the initiative of the Parliament, we have moved the issue into the regional level. A policy paper is being prepared to educate local legislatives in this respect. This will be our first political policy paper of this type. We expect that the paper will cover basic mainstream issues relating or rather describing the state of the issue. What is most important, we expect the paper to set out basic avenues of future development. This involves an enormous amount of practical text making. However, this paper is very needed as a strategy, and once we have this strategy on our table, we will be able to push the process further ahead. Any such paper will, in one way or another, mention mediation as an institution and as an instrument of dispute resolution. I will not bet my money on the exact role of mediation that would be attributed in this paper to it, but the fact that it will be there, that's for certain. Another important aspect to keep in mind is the Code of Administrative Procedure, which is being drafted as we speak in the parliamentary structures. However, I hope that the legislator will hear me when I say that before we draft any binding legal text, we have to have a strategy. We have to have a vision that we can offer, and that would modulate every imperative text that will be adopted in the legislative bodies. I have skewed the glance your way, fully aware that the Code of Administrative Procedure is being actively discussed, and I hope you, as a member of this discussion, will hear my voice. I will not waste your time explaining the importance of mediation to you. For the government, for the bureaucratic establishment, if you wish, mediation is crucial. So I hope that your administrative procedural code will be based on this mediating philosophy. Thank you for your time. Please excuse me. I have to go. Thank you so much, Vladimir Nikolaevich. Well, indeed, I'm very thankful to Vladimir Nikolaevich for his strategical vision that he offered here and now. Indeed, mediation is the highway of our future development. Unfortunately, the law that we have at hand right now is pretty restricted. It restricts the sphere of application of the mediation procedures only to non-public entities. However, in the future, we might expand the scope of application of mediation. Indeed, the law is being in its first reading. We do have a national organization of mediators, which is an association or four legal entities the Association of Lawyers, Chamber of Commerce, Association of Private Mediators, and Association of Judicial Professionals. All four stakeholders have a consolidated position in terms of criticism of the effective legislation. The stakeholders have initiated adjustments, legislative adjustments into this law, which was the beginning of the whole story, which led to the first reading of this piece of legal text. Initial steps were unsuccessful. However, we have to be patient, and things are indeed moving forward. Now I would like to give the floor to Hans van Loon. He is a great enthusiast of mediation procedures. We will be happy to hear your opinion, sir.
Thank you very, very much. I'm delighted and honored to be in your midst. Last January, my colleague Louise Ellen Teitz and I had the honor and pleasure of receiving you, Mrs. Chair, and Diana Wallace at the Permanent Bureau. We had a wonderful discussion. It lasted hours and hours, and we had the feeling that we could have continued for many more hours, but it was probably led one factor that led it to the invitation for me to be here. But more importantly, Professor Shamnikashvili ensured a Russian translation of this important publication of the Hague Conference, which is on mediation, in particular in the family law field. So we are extremely grateful to you for that Russian translation, because we would never have been able to do that ourselves. I'll come back to this guide in a moment. I'm also very honored to be here in the presence of Professor Yakovlev. Benjamin Yakovlev has been, in fact, the man who brought Russia back to the Hague Conference. Perhaps a little excursion there into history. The origins of the Hague Conference on Private International Law, the intergovernmental organization that I'm representing, go back to 1893, when a Dutch visionary, Tobias Asser, and a couple of friends, including Fyodor de Martens, had the idea that it would be good to bring countries together to solve cross-border problems that you and I may have in the family law field, in the commercial field, by negotiating multilateral treaties. That was a fundamental new idea at the time, and Asser, with the support of Martens, convened the first Hague Conference in 1893, which is at the basis not only of our organization, but the whole development of The Hague as a center of justice and peace. And finally, there's another friend and I should say, that was the Martens. Don't go too quickly. Russia was so very much present at the beginning, but then in the Soviet times, no Soviet Union at the Hague Conference. So it took until the last part of the last century that when there were these new developments in Russia, that the contact between the Hague Conference and Russia were re-established, and Professor Yakovlev has been the one who saw this as an important matter and did his best to bring Russia back into the Hague Conference, and Russia has been a member since 2001 of the Hague Conference. I wanted to say that I have another friend on the panel, and that is Mr. Fernando Pereira, who is not only one of the main architects of the e-justice system within Europe, but he's also a superb diplomat, and he's been a tremendous support for the Hague Conference in the transition period, which we faced a decade ago, when quite suddenly the European Union was given legislative powers in the field of private international law, and that new situation had to be integrated into the wider organization of the Hague Conference. And it's been a very subtle process in which Mr. Pereira's help has been critical. So, as I said, the Hague Conference is an intergovernmental organization with now 72 members, including Russia. Our mandate is to work for the progressive unification of the rules of private international law, rules that deal with cross-border situations in various fields. And our main vehicle is the International Multilateral Treaty or Convention. We've produced some 38, almost 40 conventions since the Second World War. And Russia is a party to 6 of these. Convention on Civil Procedure, which is an old one, has been replaced by more recent conventions, 2 of which Russia has ratified as well. The Convention on Service of Documents Abroad, on Taking of Evidence Abroad. These are procedural conventions. There is the Convention on dispensing with red tape in legalization, the Apostille Convention. Russia is a party to that one as well. And then, more relevant perhaps to this seminar, in 2011, Russia became a party to the Hague Convention on the civil aspects of child abduction, wrongful removal of children, the Child Abduction Convention. It was a milestone. And on the 1st of June this year, so in a few days' time, Russia will become a party to another important convention in the field of child protection, the Hague 1996 Convention on Protection of Children. And these 2 conventions complement each other very, very much. Now, the focus of the work of the Hague Conference has been very much on determining in an international situation to which court you should go, may go, have to go, must go, what law is applicable, whether judgments will be enforceable in another country, and ways of assisting in legal cooperation. But increasingly, we've seen that mediation and other forms of family alternative dispute resolution have become important to our work. And that is particularly the case in the family law area, but also in the context somewhat of the commercial field. So we are talking about a rather specific area, but it's perhaps nevertheless relevant because it's cutting-edge work, if I may say so. So first, a few words about the emerging importance of mediation in cross-border family situations, and particularly in the context of the 1980 Convention, which I just mentioned, and the 96 Convention. We see in our world with easy travel, the end of the Cold War, but also difficult situations as a result of religious problems, we see that there are many more cases where mixed marriages in particular do not work properly, and they result in parents taking the law in their own hand, children lose contact with the other parent, and children are becoming increasingly vulnerable in those situations. And we need measures to remedy that. And we strongly believe that whatever we do, we need to have a clear legal framework. It's important that when there is a family dispute, that we know to which court to go, what law should be applied. It's important that you know when you have a judgment of that court that it will be enforced in other countries, and that countries assist each other. So that legal framework is important. But it may not be enough, and already the negotiators of the 1980 Convention saw the point. The 1980 Convention provides a remedy for the return of children, but it also sets up, in the first place, a system of cooperation. Each country has to designate a central authority. In Russia, it's the Ministry of Education. In the United States, it's the State Department, for instance. And these central authorities do not have the task to grab children and return them to the other country. They have to find, in the first place, an amicable solution to make it possible for the parents perhaps to come to terms with the problem and to find a way of agreeing either on the return of the child or the other parent accepting that he or she just has an access right. I'll come back to that in a moment. So that was already an intuition in the times of the negotiations on the 1980 Convention. And what we've seen is a progressive, more explicit recognition, in particular of mediation. Because if you look at the 1996 Convention, it does not just speak about amicable solutions. There is a specific mandate for the central authorities to facilitate, either directly or through public authorities or other bodies, by mediation, conciliation, or similar means, agreed solutions for the protection of the person or even the property of the child. There's a similar rule in our Convention on Protection of Adults. And a next step was made a few years ago when we drew up a convention on the recovery of child support, maintenance, alimony, which says not only that central authorities shall encourage amicable solutions, again, through mediation, etc., but also that contracting states should make available in their internal law effective measures to enforce decisions, and these measures may include use of mediation, conciliation again. So there's mediation not only at the stage of the initial stage in the first country, but then also in the other country where the decision has to be enforced as a way of finding an amicable solution. In the context of child abduction, international child abduction, mediation is of increasing interest. Why is that so? The Child Abduction Convention, negotiated 30 years ago, is a rather precise, powerful instrument to ensure the return of children. But we've seen in recent years more cases where, for instance, a young mother with a young child cannot live in the other country and decides to go back perhaps to her home country with the child, and then the father claims the return of the child. In reality, in some of these cases, perhaps even in the majority, the point for the father is not so much to get the child back, but to get a good contact, access to the child. So using the Child Abduction Convention in such cases may be a little bit of an overkill, which is not really what the parties in the end want. And so in such a situation, rather than mobilizing the effective mechanism of the convention for the return of the child, it may be better to consider mediation that will avoid that the child would be exposed to another relocation. It would ensure that we were spared for long court proceedings, and it would also help reducing tensions between the parents, which is ultimately, of course, also in the interest of the child. Court proceedings about children are the most difficult ones for the persons concerned, but also for the court. Think of King Solomon in the Old Testament, isn't it? That was even more difficult than deciding about cows and calves. Issues on children are very, very difficult and painful, and so mediation can be a very important way to deal with it. That doesn't mean that it is a magic solution, of course. There are clear difficulties in international cases. There is the language barrier often. There are different cultures, different religions. There's a geographical distance. So it requires very specialized people, experts, to do this. You also need to have at least a basic knowledge of the differences between the legal systems, legal requirements involved. You need to know what the effect may be of your mediation, assuming that you make one? Is it really enforceable in the other countries? So it's not an easy matter. And yet, our governments in several meetings, first in 2006 and then 2011, 2012, have encouraged us to explore this further and have encouraged each other to work more through mediation in international child abduction cases. Always having in mind that it should not be so that mediation cuts through the effectiveness of the return mechanism. Ultimately, if the mediation fails, you should be able to return a child. And if the mediation takes too much time, then of course the effect will be that the child gets rooted in the country to which the child has been taken, and then the whole matter of returning the child becomes illusory. So it's a delicate balance of effective mediation and ensuring the integrity of the legal framework behind it. What has become of special interest to us is the question of, yes, you have a mediated agreement, wonderful, but can it be enforced in the other country? We're not exactly clear what the difficulties are, what the issues are, so we've set up a special working group to look into that question in more detail. Now, one major step, I think, that our governments have encouraged us to make is this guide to good practice on mediation, which exists in Russian, but not only in Russian. Thanks to the European Union, it is now available in all the official 22, 23 languages of the European Union, because the European Union has recognized this as a useful document for purposes of their own instruments. All this is in the framework of existing legal instruments. But there is another interesting aspect. We've seen that for some countries, in particular countries where the Sharia is important, so we're talking there about countries south of the Mediterranean, east of the Mediterranean, but also Pakistan, Bangladesh, Indonesia, that these countries still have some problems with joining the Hague Conventions. So there is no legal framework. But better do something than nothing. So Western countries and these Islamic countries, if I may say so, that's not a correct word, have developed ways of coming to terms with difficult cases in a Moroccan-Canadian marriage or an Egyptian-French marriage. And there are tens of thousands, perhaps hundreds of thousands of these mixed marriages, which unfortunately do not always work well, and where you have these problems of the relationships between children and their parents. So we have brought together judges and experts from different countries, north and south of the Mediterranean. In Malta, we call it the Malta process, where we give these judges hypothetical cases drawn from practice and let them discuss them and come to decisions. And the beautiful thing has been that in many of these cases, these professionals come to similar conclusions. Mediation is of critical importance in that context, and we've set up a working party on mediation consisting of representatives from Australia, Canada, Egypt, France, Germany, India, Jordan, Malaysia, Morocco, Pakistan, the UK, and the United States of America. They work together to help stimulate the creation of centers where people can go to get information about mediation, to facilitate, to tell them where to go, also to develop standards regarding identification of proper mediation services, about the mediation process, and about mediated agreements. A number of countries have already set up such central contact points. Our next step will be a meeting in November in Doha, in Qatar, with a number of countries there in the Gulf Council states to encourage them to set up similar structures, because these countries are not yet ready to join the 1980 and the 1996 convention. So it's in these cases, it's a substitute. So we will go on promoting the ratification of the Hague Conventions, but in the meantime, mediation is the critical component of our work with some of these countries. Just a last word on mediation in the commercial field. There's not much that I have to say, but picking up on what Professor Yakovlev mentioned, court mediation, we have a provision in an important Hague Convention on choice of court agreements where we provide for the enforcement of agreements concluded by the parties outside the court and then submitted to the court or during court proceedings, which are given the same force as a judgment has. So that is an effective way of giving effect at the international level, at the cross-border level, to mediated agreements. But I'm sure there is much more to come, and it comes not top down, but from bottom up, because in so many countries initiatives are going on in this field. And in fact, I just participated in a meeting on the 1980-1996 convention, and there was a representative from a mediation organization who said that they had already practiced some mediation cases with regard to the 1980 convention. Not with great success, I understand, but there's a beautiful task for you. Thank you very much.
Thank you very much.
Thank you, Mr. Van van Long. And we see indeed that mediation is gaining more and more importance and popularity, including our country. In this country, we see so many cultures, so many religions. And even if we live in one legal framework, we should take into account the fact that we are carriers of various and different cultures. We have different beliefs, religious beliefs, and we're trying to say that mediation is a very powerful and useful and important tool which we need as a standalone alternative, positively alternative method, which would allow citizens of this country to protect their interest through protection of their interest and through reflection of their interest. And in this context, I would like to give the floor, with great pleasure, of course, to Konstantin Dobrinin, so that he should share with us some of his ideas as to how mediation could develop in this country. Thank you. Good afternoon, dear colleagues. I would like to welcome you all from the upper chamber of the Russian Parliament. I'd also like to thank Susanna Avtandilova for her contribution. It was only recently that we in the Council of Federation conducted a very good event on round table on mediation. And what was important, which it was noticed by all participants, some of them held opposite opinions, that it was progress in a positive discussion. It thought that everyone were on one side of the fence, so to say, while they belong to various platforms. When I started to think about bullet points for our roundtable discussion, I accidentally actually understood that the state of mediation in this country was better reflected by on pad. Why? When I started to print a pad, the Russian dictionary does not know the word mediation. It wanted to replace mediation, which I typed, with the word meditation. And I recall the story, which story of my friend. He told me that 4 years ago I was present at a Russian-French conference which addressed notary sanctions as a preventive justice. In the process of discussion, he posed a question to one of the speakers, which boiled down to the following: whether mediation is a standalone notary service, and if so, how? None of our notaries And one of the notaries started to say that we notaries always mediate with our clients. Whatever notary action we do, we meditate with our clients. Everyone thought that he made a mistake using meditation instead of mediation. So, but then we realized that he was really using the term meditation because he did not understand what mediation was all about. What do not understand what to do? We should assess the present-day situation with the mediation in Russia. De jure, excuse me, it is 2 years old. The law was passed 2 years ago, and de facto, of course, it's much older mediation. I mean, when I first came in contact with mediation about 10 years ago, when I was a corporate lawyer, and we had huge corporate dispute, and I understood what mediation was all about. And that we spent 3 years in vain waging a war, legal war. And we filed 300 legal claims all across Russia. Well, what we actually needed was to find a good mediator and come to terms with the opposing party. So whether it's work now or not, I think de facto it doesn't work. De jure it works. If we look at the statistical data, then we'll see that in 2012 there were 11 cases with mediators. In 2013, 10 cases. And if we compare it with the number of court, applications, and we have done 15 millions, and under 25 millions, we see that if every 10th or every 5th or every 15th person, the difference is huge. Something should be done. Why the situation is such? The mediation triangle is the court, arbitration court, citizens, and mediators. Everyone is interested, all three parties are interested in having mediation. It should be existent and should be, but the court, with all due respect, treats mediation somewhat differently. Well, they say, yes, it should be done, but okay, do something on your own. Citizens, by and large, do not have good understanding of mediation, considering the fact that even some lawyers do not know what mediation is all about and how different it is from meditation. But nevertheless, mediators are modest people, and they are still in the process of meditation. When I started to think as to why in Russia it is so, I thought that we should try to find the answer not in the legal, domain, but rather in a philosophical, in sociological domain. We can recall Gumilev, his theory of ethnogenesis. We may think about the genesis of nations. We as a nation are a conflict nation, but are not a litigation nation. We are not prone to litigation. It's not in our historical tradition, because litigation has as its objective the resolution of a conflict. In Russia, it was somewhat different. Has been rather different historically. The history of Russia speaks about that, because until 1917 we had 88% of the illiterate, population in this country. Between 1917 to 1989, the perestroika was a situation. When Berdiaev compared Russia with a woman, Russia has, he said, a woman, soul. Russia has not gone through the, experience of court honor. So the majority of the population are distrustful of the court proceeding. And if we look at the statistical data for the last 20 years, we see an active, sometimes senseless court proceeding. I know that we have litigators here and court lawyers here, and they know that quite often in the process of the legal proceedings, a party can do something which runs counter to its, purpose, only with the purpose to win, rather pursuing resolution of the conflict in its interest, but only to win over the other side, to prove that it's better than the opposing party. Sometimes it's detrimental to their own interest. What is is the negative? What is the downside for that? Nowadays, court is the only instrument for resolution of the conflict solution. Mediation oversight propose such an alternative. We have a legal tandem, and mediation and court should create such a legal tandem. How we can help? Well, mediation cannot be developed and promoted and advertised from top down. The government, the state, should create conditions providing legal framework. I agree with the previous speaker saying that one of the points of the code of administrative proceedings. What else can be done? We do not need cheap justice. We try to think about the, level of court fees. By that, by raising the court fees, we will kill unnecessary case, and we will have people to think whether they should go to court at all, whether they should try to first come to terms in a peaceful way by inviting a mediator. So, we are having a basic problem. Our people cannot hear each other. There's a civilization. We need to change our civilization. We need to learn to speak to each other and to train our citizens in talking to each other.
I'm an optimistic person, and I am convinced that mediation is the way of the future. And my wish to the mediation profession is to be faithful to this belief, to stand on firm ground, and we will eventually come to our final goal, civilized mediation procedure. Thank you so much for your opinion. We like your proposal that our justice must cost money, must be expensive to cut down the number of cases heard in law. Expenses is one of the limitation on the way of proliferation of law cases. Unfortunately, our citizenry are so inept in courts that they have to go through a certain learning process. They must learn, behave in court and use that instrument appropriately. That was our thinking just a few years ago. Now our thinking is changing, and it is imperative to change the mindset. It is high time to raise court expenses, to cut down the number of motives driving our citizens into courtrooms. Our citizens must first think how to mediate their disputes and only then take action. I give floor to Madam Wallace, Diana Wallace. She's a person who was dealing with those issues on a European-wide level, teaching and education, the population to use mediation for better life in Europe. Please.
Thank you, Tatiana, and thank you very much for inviting me here today. It's a real privilege, and it's a privilege to hear what's happening in this country, and also to hear again the great work that goes on from the Hague Conference. But what I wanted to do was to also, to some extent, concentrate on this ability of mediation to jump barriers, jump frontiers, cross legal cultures and boundaries, because this is, I think, where the future inevitably takes us, and what has been so important from a European perspective. So I will speak as a European, but also as a British European. And let me start maybe with a few reflections on the way the nature of our legal services, or what I would like to call the provision of dispute resolution services, is changing in the modern world. If I think back, even in my own lifetime, to, I have to say, more than 30 years ago, when I started out as a lawyer, I started out in a sleepy market town just north of London, and I learnt how to draft wills. I learnt how to draft documents that transferred land. I learnt how to represent clients in small claims. And there were no mobile phones, there were no fax machines, single market where people can buy and sell and do business across boundaries with reasonable ease. But alongside that, we also tried genuinely to create an area of justice, an area of civil and commercial justice to actually help Europe's internal market work. But it is hugely difficult with those different legal cultures and traditions. We tried to find ways using the traditional instruments of private international law to help our legal systems talk to one another, to find simpler rules to allow individuals, ordinary citizens, to obtain cross-border access to justice. And of course, all this has been going on at the same time that the internet has opened up the world to all of us. I can sit in my home in Yorkshire and I could buy something from anywhere across Europe or across the world. But what happens if things go wrong? We've bought online. We probably want to have the facility to resolve our disputes simply and easily, possibly even online. But as I said, one of the things that appealed to us as European legislators was that mediation had this possibility to cut through our different legal traditions, to provide a leap that would allow us to talk to one another, that would actually empower people to resolve their disputes in a more simple manner. So we've had in Europe, now it's been enforced, implemented, we say, a mediation directive. It's been implemented for the last year. Now, it's not a very prescriptive directive. It's not very detailed. What it actually does is give a loose framework for the use of mediation across the European Union. But it has been hugely important in promoting mediation, in ensuring that where parties reach an agreement to a mediated dispute, that agreement can be enforced through the courts from one country to another, if needs be. So in that way, it has been extraordinarily important to have that piece of legislation. It's delivered a push to mediation across Europe, and it helps us deal with those difficult differences that we have. But we're about to enter into the next phase, which will be, I think, even more exciting potentially. I spoke about the internet. The internet, like Europe, attempts to be borderless. It again has the possibility to escape, for better or for worse, national legal systems. So again, we need to use this medium in a sensible way. So how do we provide online dispute resolution services, perhaps using mediation, perhaps using other forms of ADR? Well, again, Europe is about to finally sign off some new legislation, a regulation and a directive. And you'll hear more about these later from Fernando. But again, this will be an important impetus and a way in which I hope that we can try to keep up with the way technology is changing the way we live our lives, the way we do business, and the way we want to solve issues between us when we have problems. You know, we can mediate now by telephone, mediate through Skype, through the internet. These are things that people will begin to be much more at ease with and will expect. As I said, mediation goes beyond state boundaries. I look at the state of legal services in my own country. Some people see the United Kingdom, particularly England and Wales, as being in the vanguard of how things are developing in legal services. Certainly, we were amongst one of the first countries to liberalise our market for the provision of legal services. You can now almost get legal advice in your local supermarket. It's really changing. But by the same token, a thing that was unthinkable when I was a young person, we see law firms becoming insolvent, going bust. We also see a phenomena of our courts, and I am inordinately very proud of English courts and our legal system. But if we look at some figures released from a study last week, you see that bit with the mediation directive, and indeed other countries across the world, with putting a legislative framework in place for mediation. But there is still a problem. We speak about the confusion between mediation and meditation. If an ordinary citizen has a dispute, their natural instinct is still to go to the court, to go to a lawyer. That's the cultural shift we need to make, that the natural instinct should not always be to go to a lawyer. People need to know about mediators. They need to know where mediators are, and they need to know the service that they can provide. It needs to become more natural, more normal to use this as a solution. And therefore, there needs to be much more promotion of mediation. And alongside that, given the changing nature of legal services and dispute resolution services, my plea also for the future would be a huge change in our legal education at university level and elsewhere, at professional level. It should be normal, it should be ordinary for lawyers in their education to learn about alternative dispute resolution, to learn about mediation. This has to become part of being a lawyer. So that's my view for the future. We've come a long way, but if we're to catch up with the way our world is rapidly changing and the way all of us live our lives, then we've got to do much better in terms of what we offer to resolve disputes across the world. Thank you.
Well, thank you so much, Diana. Indeed, the world is changing. Values are changing. However, there has to be something basic in this world, because humans are humans, and they don't change as fast as reality is. To follow up on your ideas, I'd like to say that indeed it is an instinctive feeling. If we are hurt, we seek assistance from the legal profession. To buck this trend, to buck this instinct, we have to make lawyers educators. Educators have to become what they have to be by learning to mediate, by embracing mediation. Therefore, educating legal professionals is a basic condition of future progress in mediation as a social instrument. I believe that mediation and knowledge and skills of mediation must be part of professional ethos. Just like in any other profession, like medical profession, a doctor has to be honest with his patient, so the lawyer has to be honest with his patient and first offer possibilities of mediation. Now I give the floor to Madam Alexeyeva, who is the judge on intellectual property. Intellectual property rights court is a very important institution. This is most unprotected and yet most valuable asset in any country or any society. Oh, thank you. Thank you for this opportunity to speak out at this forum and at this particular round table. I do believe that things that you are discussing here today is the way of the future. Given appropriate assistance and social political push, we could advance very seriously in reducing the body of litigation in any society. As a practitioner, as a court practitioner, I'm very interested in studying this issue. We are the only specialized court with the sole mandate of settling disputes related to intellectual property. This is a very understandable reason why our court and we as staff of this court are so much pro-mediation. There to pump money, to pump ambition. This is a very aggressive type of behavior, very antagonistic situation, driving people not to find truth or justice, but to hurt the other party. They seek victory, not a solution. Of course, a judge will eventually carry a decision, but any such decision will be only part of another conflict that would lead to yet another round of proliferation of judicial litigation. The parties would usually long forget what the story was in the beginning. They would be totally engaged and overwhelmed by the conflict itself. Therefore, this is an area which is crying out for mediation. Indeed, that has to be someone that could settle down tempers, who could sit people down and talk to them with a voice of conscience.
Mediator is a good psychologist who can understand where the point of contact could be, where the points of conflict are there, and how to bring down the level of the conflict so that parties can find themselves the way to a solution. Because when you take away the emotional component, then it's sufficiently easy to find a solution. But this is something like in the format of preliminary survey. I explains why we thought that it would be necessary for us to engage in this work for the intellectual property rights court. Even without waiting for the beginning of the work of the court, it will actually start to operate only in June. We have already undertaken a number of organizational steps leading to sustain this idea, and those steps were made in a variety of domains. And I can say that we have signed an agreement for the cooperation with the Center of Mediation and Law, and it's not the only agreement which we want to put in place. We intend to put in place similar agreements with other organizations providing such services, but now we work with the Center of Mediation and Law in a very say, close way. Next week we will conduct a training session for judges. It will last for 4 years for judges. So we will discuss with judges the methods of dealing with various parties. That will be the knowledge of psychological aspects which will enable judges to behave better, being able to restrain from becoming involved in the emotional aspects of the litigation. So a mediator should be should be able to distract himself or herself from the emotional aspect of the dispute. So there will be another of groups which will get a different set of knowledge. We will conduct training sessions for judges, for assistants of judges. The curriculum will somewhat different. For other, say, facilitators. So we'll have different, slightly different curriculums for all of them. So this is an educational, a training section, a training domain which we are currently engaged in. The second domain deals with the organization of mediation service in attached to judges. Well, earlier. Someone spoke about the mediation and its application trans-border disputes. So we have problems when you look at disputes where several jurisdictions are involved. We have difficulty to find a mediator because a mediator in such case should be a person who should know the mentality of very legal mentality of the students, but that shows the way students treat, accept, view this particular person. So, and I would like perhaps that we should make up a list of mediators which would also have references or remarks or comments made by parties whom the mediator helped or did not help. And we should also perhaps should have an ability without to have first mediator aid facility in a courtroom who can render a situation if the need arises on an immediate basis. Quite often we have questions coming from the audience whether the mediation service would be a paid service who will work in a court. I can say in the court those people who work to go to work will render their services for free. We're speaking about the purpose of developing the institution of mediation, and I think that to develop this institution should be done on a free basis. We want first to show how good we are in providing the mediation service, but if parties finally like this mediator, if they understand that he is a good one, in future cases when they solicit the services of this particular person, then they're most welcome to pay to this person whatever fee they may agree with him. And not to go too far away from those issues which are part of our agenda, I would like to use a few moments to respond to some of the ideas aired in the course of our roundtable. Well, meditation. This may sound funny. We have come to meditate. Some people often mix up these two terms, but there is an issue. Because we say that the population at large do not go to mediators. But if you ask someone in the street whether you're going to the mediator, the resulting response will be, what is the mediator as well? Does he meditate? People do not understand the terms of the mediators. Well, you remember when, the Russian car Lada originally was marketed in Russian in foreign markets as Zhiguli. So I think perhaps we should not not use mediation in Russian, but we should use another Russian term, which would which would be a Russian term. We will not shy away people from the office of a mediator if we use instead of the foreign term mediator a Russian term with a Russian root. Well, the pacifier, or well, not pacifier, but facilitator. Well, there are a number of Russian words which can be used instead of a mediator. So this is a comment. Well, conciliator, perhaps, is the right term used in Russian when we use the Russian term. And the last comment which I would like to make is that some of the speakers said that the mediator should grow from the bottom. Kind pension. Thank you, Ludmila. Indeed, it's very important for us that in the court, in your court, mediation will be developed, and in those issues, from the very inception of this process, we thought that we should develop a list, a pool rather, of Russian mediators who would specialize in intellectual property rights. We have already started this work, and we engaged Argaris and some other associations in this work. And on top of that, we discussed on many occasions the need to set up a pool of a list of international mediators who can act as mediators in certain cases. I came recently, I was chosen as a member of the Academy of National Mediators. I requested them to give us a list of the best mediators in the intellectual property rights worldwide, so that we can solicit their services and include them in this pool. So I think that will be of great help for all of us. And at this note, I would like to give the floor to Mr. Fernanda Paulin Pereira. He's the person who can tell us, without many other matters, from the very initial steps, he was by the cradle birth of the system of electronic justice in the European Union. And I believe that it will be of great interest for all of us to hear about his experience, and he has a lot to say. You have the floor, sir.
Well, good afternoon to all of you, and it's really a pleasure and an honor to be here. And I have really the chance to be at the same time responsible for judicial cooperation in civil matters at the Council of the European Union, and to be responsible for e-justice in particular, also at the level of the Council of the European Union. And mediation touches exactly the two issues. It's the civil law, the civil cooperation, and e-justice. And you will see in a moment that the roads cross between themselves on this very important matter. So in my less than 10 minutes that I have, I will try to go through my presentation, touching two issues, if my PowerPoint works. The first one is the legislation on mediation, and it was already mentioned this recently, and I will say what is the point of the situation as of today. I think that can be interesting for you to know. There are a lot of things going on this matter. And secondly, I would like to give some indications about e-justice and mediation. It's a new idea. It's a new European idea, and we have a lot of things to do in the future. Now, I will try to extract in the end 2 or 3 conclusions in this what we called important moment in the construction of mediation and of e-mediation. Now, on legislation, we have 3 instruments that were adopted. One is the 2008 Mediation Directive. The second one is on the 2013 Mediation Directive. And I say it's adopted because it will be signed next week. So perhaps in the first hand I will say it to you, what is going on in this matter. And we have the third one, is the ODI regulation. And we will not call it a revolution, but it will be really speaking about the future. And you will see that the future is already here in the work of the European Union. Two additional instruments are of great importance. One is the UNCITRAL negotiations. It's a worldwide negotiation. I can tell you that the Council adopted 3 days ago a mandate of negotiations, and the Union will go to New York next week to negotiate with several states, including Russia, on the possible conclusion of an instrument, a worldwide instrument on online dispute resolution. And of course, as the Secretary General of the Hague Conference just mentioned, we are looking to the Hague Convention and the Hague Conference, and we will tell you in one word when I will come to this. But perhaps it can be useful if, in very short, I go one by one to the several instruments that were adopted. The Mediation Directive, it was adopted in 2008. It was new. Don't believe that for the European Union member states, mediation was known. It was completely new for some of them. And a general framework, as Diana already mentioned, indicated the key elements that was necessary to adopt at national level. And those key elements came as a consequence that member states were obliged to define a framework for mediation at internal level. So we had for the first time a definition of mediation. We had for the first time of a definition of a mediator. But we don't say who should be a mediator. It can be a notary, it can be a lawyer, it can be any person that has the skills for that in the context of the directive. And we create the conditions that when we have an agreement on mediation, that agreement can be enforced in the other member states. And we have some conditions. So it means that the mediation agreement can cross the bridges of the member states and be enforced in the other member states. 2 basic principles were defined in this directive. Confidentiality, so it means that the mediator and his team, they should keep confidential all indications, all the process on mediation, with some exceptions. And finally, that mediation should be accepted, and this should have as less as possible consequences in terms of limitation and prescription periods for the court. The parties should not be penalized by the fact that first they go to mediation, and when they don't have a solution, they have to go to the court. Now, the instrument that will be adopted next week, it will be signed by the Council and by the European Parliament. They are the 2 co-legislators in this area, is the Mediation Directive. I will not go into the details unless you would like, but I would like to say only 3 things on this very important directive, because it's really the second phase of making mediation in Europe. The first one is the requirements to ADR. So there is a list of 7 conditions that imposes that mediation must respect. It's not only that it's efficient, it's not only because it's impartial, it's not because it needs to be in a competent way, but we need fairness, we need impartiality, we need to do mediation in a professional way. Mediation is not a conversation in a pub. Mediation is a professional system that should one day be an alternative to judicial proceedings. It's a serious process that we should give to people, to citizens, and to enterprises in Europe. The second one is there is a set of information of cooperation that is defined in this directive. And the third one is that competent authorities will be created in each and all the member states of the European Union in such a way that they will have a role of coordination in terms of mediation. Now, this directive, hopefully again signed next week, will be applicable as normally as from July 2015. So we still have a way to go, and the member states will have the possibility to implement all these matters, all these rules, all the principles at their internal national order. Now, with this general directive, second generation, on trying to draw up a system of mediation, an alternative system of solving the problems, we have the ODR regulation. And the ODR regulation will also be accepted next week, at the same time as the ADR regulation. And the ODR regulation, it means that it is an online dispute regulation. And it was, as it was said by Ms. Diana Wallis, it is not fair that we give the possibility to people to make business online, to go to internet and to conclude agreements. And then when they want to solve the problems, they don't have a mechanism to solve the problems in a simple, non-costly way. And the ODR regulation tries to give an answer to this issue. Again, I will be very short, but only to say that the objective of the regulation directly applicable in all member states. It means that it will not be required, not only not be required, it will be not possible in the areas decided in the scope of the regulation that member states adopt other set of rules, so it's directly applicable in all member states. We create an ODR platform. And the ODR platform, it means that we have a system that each member state will have to indicate an authority, at least 2 persons in each one of the member states, that will manage when you have a cross-border dispute. And it means that the person, a consumer, as a rule, should submit an application to the system, to the ODR platform. There will be a processing and a transmission of a complaint to the addressee, everything in electronic terms, and they will try to choose an ADR entity. And it means that the ADR entity will try to solve the problem. So, as you see, this regulation will give an enormous impetus to mediation in the context of the European Union. So this will boost the possibilities to have mediation at the European level. Now, the fourth one, and I said it, and I will be very short, is we have the ancestral negotiations, also not ODR, and we hope that in the future, in the near future, we can conclude work on this, and I'm sure that I can tell you that member states and the European Union is ready to work with Russia to try to have a solution that is good for you and profitable for the interest of making ODR at a worldwide scale. And the last one is the Hague Conference and Mediation. And the Secretary General, Hans van Loon, just said a word on this. But it's very important, because when you have mediation, especially for certain member states, when you have mediation, you don't need to apply exactly the rules if this is not against the public policy of the member states in question. And so if you have, for example, an abduction, and it's an abduction between a country, for example, the north of Africa and the south of Europe, we don't have a system. We don't have a framework. We don't have a legal framework to solve the problem. And how to do it is putting people speaking together. And this is the starting of a mediation process. So the Malta process, mediation process, can be really an alternative solution to very rigid systems where the law does not apply. Now, this is what I wanted to say about legislation, and I would like to go to very, very practical aspects. And this is e-justice and mediation. We have an action plan. I will not go into the whole details of it, but only to say that in the context of the European Union, the member states, the European institutions are working together with a view to having a system of justice online. And when I say justice online, it means that we want to have a system of information about justice. And nowadays you can already visit this portal, and I will show it in a moment. We have the possibility to improve, to encourage, to promote the cooperation between judicial authorities between the member states, for example, in terms of legal aid. And we have a last one. It's extremely ambitious, but I have to say that even myself, that I'm working in this area since several years now, I'm surprised that, and the last one is going to court. Can you imagine that you have a Russian person living in Rome and wanted to sue a person, defendant, in Germany, but the competent court is in Paris, and that you submit an electronic application from Rome to Paris, and the judge in Paris will ask the service of the document using electronic terms to Germany. And when you have the judgment, this will be notified to the Russian person in Rome. And the judge can listen a witness, one in Lisbon and another one in Finland, using video conferencing. Is this the future? And I would say that is already the present, and it exists already. And what we are trying to do is, in the full respect of data protection, in the full respect of people, is to make justice online. It's quicker, it's less expensive, and it's better to people. Now, we have the e-justice portal, and I would like to show you some general aspects on this matter. Now, this is the face of the e-justice portal. It's in 22 languages. As you know, we have 23 languages at the level of the institutions, but we have in 22 languages of the Union. It's free of charges, and it gives a lot of information about justice. This is the second phase. You can see that you have a lot of information about matters of justice. You have information relating to citizens. For example, you can have what are the family rights, what is the rights in legal aid. You can have access to the dynamic forms. And then you have a second column. It's business, because we give an attention also to business. We have land registers, how to know the land registers in member states. We are still working to ameliorate the system. Insolvency registers, how it goes, business registers, monetary claims. The third one is legal practitioners, and we are speaking directly with legal practitioners. We are speaking with the notaries. We are speaking with the lawyers. We are speaking with the bailiffs, the judicial officers. We are trying to put everybody in the same context, because what is justice with legal practitioners? And we have the last one, and it is the judiciary. Judiciary is the representatives of the judiciary, the churches, and the legal structures of the member states. Now, I would give one or two examples. If you go to legal professions, you want to find a lawyer in Cannes. Is this possible? A lawyer that speaks Russian. Is this possible? And we are working on this. This will come in 2 or 3 months. the lawyers in Europe, in full cooperation with all of us, tried to put this on place, and we are going to incorporate all this in the e-justice system in the near future. So, can we have mediators in the system? We certainly believe that this will be possible in the future. Not for the time being still, but we are working and we are at least reflecting on this possibility. Now, I would like to give a second example on mediation in the context of the justice system. And mediation, we have information about mediation. And you can see in this, in the screen that there are information about mediation in the context of the European Union, but also mediation at the level of national law. I give you just an example, is that if you want to know and to use mediation in France, and this is translated in the 22 languages, you have the whole indications to which bodies you should go in France. And you have an hyperlink, and you click, and you have the whole information. And it's extremely useful, because this is one of the key elements, is that we need to give information to people on mediation. And with this, I would like to come to my conclusions, and I would like to say only two things. The first one, and I think all those that intervened this morning said, and I would like only to confirm from our side, that mediation is cost effective. The statistics proves that around 70% of the mediation comes to a positive result to the parties. It is quick, it's in some weeks. In the regulation, it is indicated that the maximum period to have mediation is 90 days maximum, 90 days. And thirdly, this is tailored to the needs of people. So mediation, we should not say it's new. It's perhaps very old, because probably judiciary, before being judiciary, it was made with a person trying to solve the problems of people. And so mediation is exactly this. It's flexible and tries to give, with competent people, an answer to justice. Now, the second thing that I would like to say is that, and I would like to say it here, 12 years ago, when the first conclusions at the European Union were adopted, I can tell you that many of the member states, they were against mediation. Many of the judges, they were against mediation. And nowadays it's a reality. And we see it as a future, as an alternative system to make justice in the member states of the European Union. Many thanks.
Спасибо большое, господин Паулино Перейра.
Thank you so much. Thank you for your patience. But we still have one more speaker. Madam Konstantinova, she was patient in waiting her line. Thank you, colleagues. I know being the last one in line is not a very comfortable position, but let me say just a few words to bring across the thinking of the legal profession about mediation. What do we expect, the lawyers, from mediation? What can we do for this profession? We are an association, a non-profit organization, uniting 100 plus Russian and international legal firms. I'm talking and representing the in-house profession, segment of the profession, rather. The role of an in-house lawyer is going through radical transformation. In addition to his traditional roles of drafting contracts and reading contracts. He has to do GR. He has to manage compliance. This is a separate subject matter to be discussed tomorrow, and you're very welcome to attend to discuss the issues of a new role of legal profession in corporations. That will be tomorrow at 1500 hours. So a lawyer must be a responsible person. He must be considered a leader in the world of business. I often face a question: what is the difference between Western and Russian in-house lawyers? Our national Russian homebred in-house lawyers have a feeling of purpose. They have a feeling of leadership. They know that can bring additional value into the corporation. So this new quality, this new attribution of lawyers is a very positive and healthy phenomenon. The new role of in-house lawyers requires new skills and new knowledge. Now, of course, we all learn as we grow in our careers. It's a concept of the on-job training. On the other hand, there has to be a formal educational university background. Quite about everyone mentioned training, mentioned education, said about the need about educating lawyers to engage in mediation, to understand mediation as a new instrument. On my personal experience engaging business leaders, I try to find out what do they think about mediation. I was pretty surprised to hear the answer. Business leaders are interested. They would welcome the emergence of mediation as a practice. They would welcome a new role of in-house lawyer. They are interested in reducing the cost of litigation in time and money. However, on the other side, they kind of taken aback at the simple lack of practical experience. They don't know how such a new practice would look in practice. There are no institutions. There are no follow-up mechanisms. We have an interest. We don't have implementation. Disputes are various and numerous. Disputes in intellectual property, disputes in titles, on contracts, and whatever. Disputes in intellectual property are especially criminous. Anyway, in-house lawyers must be specialists in mediation. They must be free-flowing, floating agent in this ocean of mediation. They must realize the importance of this practice, yet current knowledge is close to nil. Now, to wind up my short statement, may I say that mediation and skillful management of mediation would add a competitive advantage to the legal profession. Managing mediation meaning being better, doing things quicker. There's an element of competition. an added value that will put any corporation, any legal office ahead of its competitors, not to mention personal career growth. And again, to wind up, may I say that an in-house lawyer must be energized or galvanized to acquire such skills, to educate him or herself. The legal profession, in-house lawyers, claim leadership in corporations. This has to be substantiated by new skills, including the skills of mediation. That must be his personal asset. Should lawyers acquire such skills, they will move things forward. Thank you. Thank you all for your attention, for all our panelists, for the audience who have come across mountains and oceans. Unfortunately, our time is limited. We could go on and on discussing every aspect of this interesting profession, exchanging personal experiences. But however, I would be amiss if I don't comment one final statement of the final speaker. We must push things forward. We must push mediation. I see Mr. Semeniaka is there at the background of the room. He is nodding his head. First, we must educate the public, to educate, starting with educating the profession, the lawyership. They have to be in the forefront of this drive. Mediation is not meditation. There's a world of difference between mediation and conciliation, arbitration, and many things of the like. This is a very separate and specialized line of activity, is a very complicated type of activity that has emerged only recently. Just a few years ago, people simply failed to understand the essence of this issue and tended to shrug it off. Let me wish you success. I hope you will continue your engagement with our roundtable moving forward.